We've got 5 minutes. If you would, please make sure your green light is on, and then state your name and title for the record. Thank you.
It is on. My name is Publius Hulda. I'm a retired litigation attorney, and I write on the original intent of the Constitution using the Federalist Papers. I do not go by Supreme Court opinions because for 200 years the Supreme Court has been ignoring the Federalist Papers and the Constitution our framers given, and they have gone off on tangents of their own which have nothing to do with the Constitution. The Attorney General's opinion begs the question. He states that states can't nullify acts of the federal government which are authorized by the Constitution, but then he completely fails to cite article, section, and verse, clause, where the Constitution delegates to Congress authority to restrict our arms. When we ratified the Constitution, we created the federal government. We listed, enumerated every power we granted to our creature, the federal government. Article 1, Section 8, Clauses 1 through 16 lists most of the powers we delegated to Congress for the government, for the country at large. We didn't put on our list that our creature could restrict our arms. We didn't delegate this power to Congress because our framers wanted the American people to be heavily armed. Alexander Hamilton and James Madison write about this in the Federalist Papers. In Federalist Paper number 46, James Madison writes, why the American people are armed. It is so we can defend ourselves, our communities, and our states from the federal government in the event it becomes tyrannical and oversteps the constitutional limits on its powers. In Article 1, Section 8, Clause 16, pursuant to that, Congress passed the Militia Act of 1792, where they required every able-bodied male citizen between the ages of 18 and 46, except for federal officers and employees, to buy a rifle, ammunition, and report to their local militia for training. Pursuant to Article 1, Section 8, Clause 11, Congress is authorized to issue letters of marque and reprisal. This is what authorizes private warships to make war on our enemies. These were the privateers who fired on British ships during the War of 1812. Our framers contemplated a people who were heavily armed. That is why we never delegated to our creature authority to restrict our arms in any fashion whatsoever. And when the federal government attempts to do so, they are usurping powers which they do not possess. The Attorney General goes by court opinions, not the Constitution. There is a vast gulf between the two. We have 200 years of Supreme Court opinions, and Mr. Chairman very kindly shared some of these 200 years of Supreme Court opinions, which have nothing to do with the Constitution. Charles Evans Hughes said over 100 years ago, the Constitution means what the judges say it means. That has been the prevailing dogma ever since, and generations of lawyers have been indoctrinated with this lie. That is why we no longer have a federal government which is held down by the chains of the Constitution. What we have is rule by five judges on the Supreme Court who claim the power to do whatever they want to us and our country. So today we have two opposites, what the Constitution says and what the Supreme Court says. Well, your oath of office requires you to obey the Constitution, not the Supreme Court. The Supreme Court is merely a creature of this Constitution and is completely subject to its terms. My third point, the AG asserts that the that the Supreme Court is the exclusive and final authority on the extent of the powers of the federal government. But our framers knew that Supreme Court judges were as likely as anybody else to be corrupt, usurp powers, and act lawlessly. So Congress, the President, and the states all have checks on the Supreme Court. Hamilton shows in Federalist number 81 that Congress's check on lawless federal judges is to impeach them and remove them from office. The President has his oath of office. as a check on the Supreme Court. The President's oath is to preserve, protect, and defend the Constitution. It is not to obey the Supreme Court. The Supreme Court was not set up in our Constitution as the superior branch of the federal government. And then there's no need for me to, well, Madison says in his report on the Virginia resolutions that it is a plain principle founded in common sense that the states, as the sovereign parties to the Constitution, are the final authority on whether the federal government has violated the Constitution, and that the states may check all three branches of the federal government, not just, they may check the judiciary, the executive, and the legislative branches by nullifying their acts. If the judicial branch connives with other branches in usurping powers, our Constitution will be destroyed if we do not stop them. This is what James Madison said in his notes on nullification, in his report on the Virginia resolution. I'm sorry I didn't have time to finish. I hope that during questions someone will ask me about the so-called nullification crisis of